Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Okay, Marie, so the next question is, are there time limits for contesting a will?
Yes, there certainly are, Tony. And again, they depend on which state you are contesting the will in. So, for instance, in New South Wales, you have 12 months from the date of death in order to contest a will. So if you don't contest a will within 12 months from the date of death, you can make an out-of-time application if you seek leave of the court or if the other side consents to your out-of-time application being made.
Well, I can imagine that would happen reasonably frequently because people live overseas, they've got family overseas that wouldn't necessarily be aware that you've passed, and they've got to start all over again. And is that normally looked on favourably in the court?
It depends on the case, Tony. So, for instance, if you've gone and gotten advice and then you just haven't brought the application within the 12-month period, well, you're not going to get an extension of time. The onus is really on the applicant to make inquiries and to do something about it. And if they want to contest the will, to contest the will within that time limit, because that time limit's there for a reason. You know, you don't want an estate to be unadministered for a long period of time. You want things to be wrapped up fairly quickly. So the legislation sets out how long you've got to contest a will, and you've really got to comply with that time frame.
So I've got European parents or English parents and family over there and what have you. If I pass, or when I pass, not if, and they find out about it 2 years later, they can't just suddenly come over and go, "Oh, we didn't know about it because we weren't in the country."
Well, you can try and make an application, but you've got to have sufficient cause for bringing in a late application. So if you were a minor, for example, when the person passed away, that might be sufficient cause because you didn't get legal advice. But if the estate's been distributed, then that's going to be very difficult for you to make a late application. My advice would be to go and get legal advice as soon as possible after the deceased person has passed away, and to make sure that you bring the application for contesting a will within the relevant time period for the state where you want to contest it.
Now we get the doozy of a question. Is contesting a will actually worth it?
Well, I would say it depends on the circumstances, and as I've said before, each case is different. So what we do at De Groots is we assess matters on a case-by-case basis. Some of the things we ask about are the relevant considerations of the court. So, for instance, the size of the estate or an applicant's financial circumstances and whether there are any competing claims. The way I like to think about it is the estate is a pie and it needs to be divided. And the question is, can you get a piece of the pie? So contesting the will may be one of the only avenues available to you in order to get a piece of the pie. So in those circumstances, you may say that it is worth it, but ultimately it'll depend on the case. So if you do find yourself in a situation where you've been left out of a will, I would advise that you speak to a lawyer and get some advice and get somebody to assess your case.
Because, I mean, let's face it, at these times it's an emotional time and a difficult time, and you may not necessarily want, or you may want Auntie Jones' cookbook, she promised it to you.
Yes.
But would it be worth pursuing to get Auntie Jones' cookbook because of the costs involved?
That's right, because these things are quite costly. So there's not only court fees that you have to pay, but then you're also paying lawyer fees. In some cases, if you're acting for an applicant, some solicitors do have what's called a contingency costs agreement, and they offer these no-win, no-fee costs agreements. Often in those cases, if you have engaged a lawyer on a contingency basis, they may be charging an uplift fee, which is a fee on top of the legal fees. And they do charge that because they've taken the risk and they've taken your matter on a contingency basis. But the fees will really vary depending on which lawyer you engage. Generally, the defendant's fees are paid out of the estate, whereas an applicant is responsible for paying their own fees. Some firms offer funding arrangements, and these can be of assistance to plaintiffs who are trying to contest the will and get a share of the estate. But ultimately, it's up to you and your lawyer to determine what type of agreement is going to be in place, and that will depend on which lawyer you engage. The main points are, when we're talking about contesting a will, we're talking about making an application for provision or further provision from a person's estate. There are certain time limits that apply. So in New South Wales, you've got 12 months from the date of death in order to contest the will. Otherwise, you need to show sufficient cause for bringing a late application or getting the other side's consent to bring a late application.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.